Everyone. It's so nice to see everyone here. My name is Mary Russell, and I'm honored to be one of the judges on the Supreme Court of Missouri. And I look at this crowd, and I've got all the experts in the audience, so I feel quite intimidated up here speaking. So at any point, please chime in and offer your personal views or edits or corrections to what I have to say. We have two former judges from our court, Steve Limbaugh and Ann Covington, two former Chief Justices of the Supreme Court of Missouri. So we've got the experts, and we have our long-standing clerk of the court, Bill Thompson. So these folks are the experts on the court. So please add to, subtract, whatever you want to do about my remarks. I appreciate that. So today I'm going to talk to you about the history of the judiciary and our courts in the state of Missouri. The building you see on the picture of your screen right now is the Supreme Court of Missouri, where I work. And it was built more than a century ago, and the Missourians who built the court carved into the stone on the outside structure of the court some real permanent ideas that they wanted to ensure would last forever. Judges and staff seem to come and go at the court, obviously, but these ideas were so important to the court. Those that constructed the court, they wanted them to be there forever. Two of the ideas in Latin are translated into where there is a right, there is a remedy. Another carving on the outside of the building in Latin is translated into declare the law, not to make it. And then the final idea carved above the doorway to the court is in English, and it is, the law has honored us, may we honor it. So those ideas in mind, we're going to go back to the beginning of Missouri as a territory in 1812. At that time, when courts were first organized in our state, there was one superior court, which was like the Supreme Court. There were 3 judges, and they had appellate jurisdiction over all criminal and civil cases. There were some inferior courts. Those would be like our current day trial courts. By 1815, there were 2. And then there were justices of the peace that were spread throughout the state, or throughout the territory, actually, to help resolve disputes that occurred in the local portions or local areas in the state. Our court system under the territory was modeled after French and Spanish civil law. But that seemed to wane away as more attorneys from the east came and crossed the river, crossed the Mississippi into the state, and brought in English common law. And it was in 1816 that the territorial legislature then adopted English common law as the official law in our state. More people getting seated. Keep up with my clicking here. So it was in July of 1820 that Missouri's first constitution was approved. And in that constitution, 3 branches of government were set up, including the judicial branch. And under the 1820 Constitution, 1 Supreme Court was established, 3 judges, and 4 circuit courts. The first Constitution also provided for chancery courts. So the difference, the circuit courts were originally designed to only hear criminal cases, and the chancery courts were designated to hear more civil cases, including things like probate, minor laws, equity. But chancery courts were quickly abolished in 1822, which left then the circuit courts to decide all of both civil and criminal cases. The 1820 Constitution also bestowed upon the Supreme Court control over all inferior courts of law. And that concept has continued on today under our current Constitution, in which the Supreme Court exercises superintendent authority over all the state's lower courts. Our first governor was elected in 1820, August 28th. And that governor then 3 months later appointed the first judges on the Supreme Court of Missouri. So interesting, and when he appointed the judges, it was with the advice and consent of the Senate. So it was the federal model that is still in place in our federal system today, but not the method that we select judges in Missouri today. The governor had trouble finding some judges that wanted to do the job. The first person he appointed was Matthias McGurk from Montgomery County, and he gladly accepted and was the first Chief Justice. But the next two men that the governor appointed declined. So it was not a coveted job in those days, and in a second I'll show you why. But the fourth judge he appointed actually accepted it. It was John Dillard Cook from Steve Limbaugh's home area, Cape Girardeau County. And then the fifth judge he appointed, actually the third judge on the court, was Judge John Rice Jones, who was from Washington County. So those three men, McGurk, Cook, and Jones, became our first three judges to serve on the Supreme Court of Missouri. The Supreme Court had no home. There was no building, nowhere to sit. They moved around. They were told by the Constitution to hear cases within 4 convenient districts, and they had to meet at least 2 times each in each of those districts every year. And those districts included, they met like in Franklin, Missouri. They met in St. Louis, St. Charles, and Jackson. In essence, they were riding the circuit. So you can see, think about transportation in 1820. Boy, you just really wouldn't want the job. That's kind of a rough, the workload probably wasn't so hard, but the transportation and travel to get between these 4 places was probably not the fun part, especially in the wintertime, or even in the hot summer as well, too, with our climate. The judges in those days had to be at least 30 years of age and a maximum of 65. And as we will learn later, that maximum age has been changed. So obviously, because of delays in Missouri becoming a state, because of the Missouri Compromise, the question of whether or not Missouri would enter the Union as a slave state or as a free state, it wasn't until August of 1821 that Missouri actually became a state. Maine entered in March of 1820, and Missouri, as we all know, August the 10th, 1821. It was President Monroe who signed the legislation that made Missouri the 24th state. Within our Constitution, those 4 circuits were designated and 4 circuit judges were selected. This map shows, I think it's the 1824 map. It shows the counties, some counties that really not become counties within the areas that are designated as the individual circuits. For example, there was a county called Lillard, which later became Lafayette. The first circuit you see up in the upper left northwest portion of the state, the judge appointed to be the circuit judge in that area was a judge named David Todd, and he was from here in Boone County. And you can see all the counties then that make up the first circuit. In 1828, the Missouri House brought impeachment proceedings against Judge Todd based on his conduct in 2 cases, one involving a liquor license and the other involving assault and battery. Following an 8-day trial, the Missouri Senate, he was acquitted. The second circuit, the circuit judge appointed there was Rufus Pettibone, who was from St. Charles County. Some of you know, Judge Pettibone later became a judge on the Supreme Court of Missouri. In fact, he was the 4th judge on our court. The third Judicial Circuit, Judge Nathaniel Beverly Tucker from St. Louis City was appointed to be the judge in that circuit. And after serving as a judge, Judge Tucker returned home to Virginia and became a law professor at his alma mater, the College of William and Mary. The 4th Circuit, Judge Richard Symes Thomas from Cape Girardeau. Do you know him, Judge Limbaugh?
Yeah, he got himself impeached too.
He's running my story, but you're right, yeah. So Judge Thomas previously had served as a territorial judge, but in 1825 was impeached by the Missouri House and convicted by the Senate, becoming the first state official removed from office. What did he do?
It says that there was tyranny in office, but then the last straw was that he appointed his son as the clerk of the court.
Well, that'll do it. A little nepotism there. Yeah, that'll do it every time. Thank you. Okay, 30 years later, the courts are evolving with the times. The 1850 Constitution, the Constitution was amended to provide for judges to be elected by popular vote. So this is a huge shift. Previously judges were appointed by the governor with advice and consent, And then in 1850, it was following the populism, the Jacksonian democracy that was sweeping the nation at the time. So now all judges in the state are elected on a ballot labeled, an R or D or whatever party they were in those days. So judges became political creatures. Well, Missouri, much like the rest of the state, our courts underwent much upheaval in the turbulent times of the Civil War. In 1861, there was a loyalty oath that was required to be taken, and judges Ewing, Napton, and Scott vacated their offices because they refused to take the loyalty oath. All judicial officers were required to then under the 1865 Constitution to take another loyalty oath. And in fact, they cleaned house. They told all judges to vacate their offices before any oath was even required to be administered. But at the Supreme Court, three judges at the time, one resigned early, and the other two refused to leave, refused to vacate their offices as the Constitution required. So they were forcibly removed and charged with the crime of, quote, disturbing the peace by interference with the Supreme Court, quote, close. I think it was a misdemeanor in those days, but it was kind of a novel crime, if you will. The Supreme Court of the United States eventually found those loyalty oaths to be unconstitutional. And in 1870, voters amended the Constitution to remove loyalty oaths altogether. But as the state's population was increasing into the 1870s, so did the caseload in front of the courts. Because the Supreme Court's caseload was so congested, in fact, it was 2 years in arrears, the Constitution was amended in 1872 to increase the number of judges on the Supreme Court from 3 to 5. And also, the 1875 Constitution required the court then to hold all of its sessions in the city of Jefferson. And that provision still exists today, too. Because the seat of government had been in Jefferson City since, I think, 1826. But prior to then, the court had met in sessions all over the state as directed by the legislature. The legislature had a lot of control over how the court did its business in those days. But beginning in 1865, the court started hearing some of its arguments in the basement of the Capitol. That's where the legislature put the court. So maybe that tells you a little bit about relationships, even going back to 1865. The 1875 Constitution started setting up intermediate appellate courts. The state population was centered mostly in St. Louis, a lot of commerce, a lot of business going on. There needed to be another level of our court system to hear some of the appeals from the volume of cases that were being tried and heard on the eastern side of the state. So initially, the Court of Appeals in the St. Louis area was called the St. Louis Court of Appeals. Of course, today it's called the Eastern District Court of Appeals. So the judges on the first Court of Appeals, 1876, were all from St. Louis. That's okay. Later, judges obviously were from the broader area, the entire Eastern District of the state. But the governor appointed those first three judges. But then after that, they were subject to election. But the first three judges were Judges Gant, Judge Lewis, and Judge Bakewell. The Constitution further provided that these judges would be only elected by residents of St. Louis City, Lincoln, St. Charles, St. Louis County, and Warren counties. So it was a smaller area than the Eastern District Court of Appeals jurisdiction and territory today. It wasn't until 1878 that the Supreme Court finally got a building to call home, but it wasn't much of a structure. There was $17,000 appropriated to build it. It was constructed by inmates. It was poor construction, hastily built, poor ventilation. Governor Dockery at the time said this was an architectural freak, wholly deficient in modern conveniences and appliances. So unfortunately, the court was there for about, I think, 30 some odd years, but they This building is located, or was located right where now the Missouri Department of Transportation is located. It's across the street from the Capitol, right there at the corner of, it would be Capitol and Jefferson, that kind of area through there. And actually, they were only there in that building for 29 years. But it was a poor structure. And in any event, that was our first home. And there's the picture of it, as you can see. Few years later, 1884, the Constitution was amended again, and now we have a second Court of Appeals on the western side of the state. For similar reasons why the Court of Appeals was created on the eastern side, now we have one on the western side, and it was called the Kansas City Court of Appeals. First three judges there were Judge James Ellison of Kirksville, Judge Willard Hall of St. Joseph, and Judge John F. Phillips of Kansas City. That court, of course, today is now called the Western District Court of Appeals. Entering into the 20th century, the Supreme Court of Missouri gets a much nicer building. There was a budget surplus from the World's Fair of 1904. It was about $176,000. That was the seed money to start the construction of the building that we continue to live or continue to work in today. I guess I lived there last night, but I continue to work in today. And for those of you who have visited the court, you know, it's right across the street from the state capitol. It's a beautiful red brick building. All the materials in the building came from somewhere in our state. It was originally designed to be a limestone structure, but because of cost, it was built of red brick from Mexico, Missouri area. The marble came from Carthage, lumber from all over in Missouri. The only product that didn't come from Missouri was what, Nick? And where did it come from? West Virginia. And it leaked. And the reason I call it Nick was my former law clerk, and law clerks give tours at the court. So this is a good segue to tell you that if you ever want to come visit the court, we have great tours from our law clerks. And sometimes if you ask if one of us judges are available, we would love to join in and also give you some history and guide you around the court. But we're open to the public. If you've got a big group, we'd like to have a reservation. But we'd love to have you come see our building and see what we do in person. But the building in this picture, it was level with the street, but later the street in front of it, High Street, was resurfaced, and now we're about, I guess, I don't know, 25 feet above grade. But the first arguments were heard in this building in October of 1907. Construction was 1905 to 1907, and money did run out as the building was built. The upper floors aren't as maybe ornate as the lower floors, but it's Bill or Judge Covington, Judge Limbaugh, what do you want to add about it?
It's bloody nice, I think.
Yes, it's lovely. And so the building was built so that each judge had, they called it chambers, and it was actually a little mini apartment. The legend goes, I don't know how true all this is, Bill, you correct me now. The legend was there was one hotel in Jefferson City at the time, and that lawyers and judges were coming in from all parts of the state. Maybe they were coming in from Southeast Missouri. Maybe they were coming in from Northwest Missouri. They all came to the city and stayed in the one and only hotel. And so it was believed then that there was a possibility that the judges and the attorneys would see each other maybe the night before in the little hotel restaurant, and maybe an attorney might say to a judge, hey, Judge, I got a case with you tomorrow. Can I buy you a soda pop? And we're not allowed to have any gifts given to us, and we're not allowed to discuss cases outside the presence of the attorneys involved in the case. So that would have been wholly improper contact. We call that ex parte contact. So to cure that potential problem, they built little mini apartments in the court for the judges to stay in. And they are adequate. They're not fine. Yeah, you can spend your own money and fix them up as nice as you want to. So there's a little bedroom area, a little kitchenette, a bathroom, space for you to work and your law clerks and your assistant. And so That's where I stayed last night. So in any event, we are open for tours, and especially next week, Monday and Tuesday, we've got extra people on board ready to give you a good tour. By the early 1900s, whoops, that was, I didn't, one behind here on you. Okay, by the early 1900s, also then, the Third Court of Appeals was created in our state, and it was created down in Springfield. It would be called the Springfield Court of Appeals for similar reasons on why Eastern and Western Court of Appeals were created. First three judges on the Springfield Court of Appeals were Judges Argus Cox of Bolivar, Judge Howard Gray of Carthage, and Judge J.P. Nixon of Lebanon. This court is now called the Southern District Court of Appeals, and it is located in the John Q. Hammonds building in Springfield. A couple years later, 1911, the unfortunate burning of the state capitol. It was February of 1911, a Sunday night. It was February the 5th, 1911. So because of the capitol being destroyed, 2 days later, the state Senate moves into a courtroom in our building. We call it Division 2, and held its sessions there while for some period of time. I've never heard how long. Have you ever heard, Bill, how long the Senate operated out of our court?
No, but of course the Senate is only meeting every other year at that time and for very short periods, so it's not like they're here all the time.
Good point. Yeah, good point. Yeah, because it wasn't until March of 1917 that they had new chambers in which they could then start occupying. You can see the pictures. Okay, then a big change came to Missouri in 1940. A difference in how judges were selected to serve on our state Supreme Court, our Court of Appeals, and later our bigger circuits in the state. Missouri is now becoming the first state in the country to have a direct experience with 3 different methods of selecting our judges. Steve, there's a seat up front if you want to come sit. You're afraid I'm going to call on you, aren't you? Another lawyer, former judge, Steve Ellman, Senator, and Commissioner of St. Charles County. Welcome, welcome. So again, to refresh your memory, 1820, judges were appointed by the governor with advice and consent of the Senate. 1850, Constitution changed the selection method to direct election of judges as political candidates. And now we're moving into the 1930s when there was increasing dissatisfaction with some of our judges, some of the ethics that were taking place in judicial elections and in judicial decision making. Some judges were considered to be pawns of major contributors. There was big contributors who were able to control the campaign coffers of a candidate so much that the judge would then vote however their campaign contributors told them to vote. There was too much outside influence on judges in their decision making. So the legislature had rejected a proposed referendum to amend the Constitution to select judges under more of a merit system. So citizens, including Rush Limbaugh and other prominent leaders in our state, proposed a new method to select judges and put the method on the ballot in 1940. And that method, the nonpartisan court plan, then was approved by the voters and has been the selection method for judges ever since. So under the nonpartisan court plan, Judge Covington was selected under that, and Judge Limbaugh and myself. You submit an application, a pretty lengthy application on your personal life and on your professional life to a nominating committee, if you will. There's fancy names for this, but I'll just give you the shorthand version, who then review your application. The nominating commission is composed of whoever happens, if you want to be a new member on the state Supreme Court, the nominating commission is chaired by whoever happens to be the Chief Justice at that time. And on our court, we rotate that every 2 years. It's a 2-year sentence, I mean, a 2-year term, right? And you chair the commission. There are 6 other members, 3 lawyers from 3 different geographical parts of the state. And those members are selected by the other lawyers in that respective area, and 3 non-lawyers who are appointed by the governor. And each of these 6 people have 6-year terms, and they're all staggered. So there's a lot of fluidity, a lot of people coming off and on this commission. And those 7 people then review the applications and conduct interviews and do background checks and look at letters of recommendation and decide 3 people they think are well qualified to be the new judge. Those 3 names then are given to the governor. The governor may know none of them, may know all of them. The governor is stuck with those 3 names to select from to pick the new judge on the Supreme Court. The governor's got 60 days to do so. If you are selected, then you serve on the court for what I call a probationary year. And at the end of that year, the next time there's a general election, your name is on the ballot, and it'll say, should Judge Limbaugh be retained in office? And no campaigning allowed, no political party affiliated next to their name. Today, you can go to various websites. There's judicial performance reviews that the Missouri Bar does anonymously. You can go to the Missouri Bar webpage and read these reviews. These reviews are made public, and hopefully the media picks them up. And you can decide if you want to vote yes or no. And if the judge gets 50% or more of the vote, then they get to keep their office at the Supreme Court for 12 years. When that 12 years is up, they can be back on the ballot again, and they can stay on the court until their 70th birthday. And then Judge Covington, what happens? Out you go, whether you like it or not. So, you know, you think about the federal system. Is there an age limit for federal judges? No. So there's one big difference. Are federal judges ever on a ballot? No. So even Judge Evelyn had to leave by the time he was 70, which he left way early. But we all have to. So that's one provision there. So does anybody want to add anything about the nonpartisan court plan? Any of you experts here? It is in effect for the Supreme Court, the Court of Appeals, St. Louis City, Jackson County, which you know is Kansas City, St. Louis County, Platte and Clay have added it on, and Greene County and Springfield. And any county can opt into the system by a vote of the residents in that particular county. So St. Charles could any day, Judge Evelyn. I'm just needling him bad, aren't I? Thank you for being, yes.
How many other states have adopted?
So lots of states have adopted in some form or another, you know, some pure exact copies, some variation of it. The statistics we get, you know, something like 30. I mean, have you all heard something different? So it's probably the most popular way, but certainly not the universal way of selecting judges. Other countries, other nations have copied this same kind of model too. Okay.
I'd add.
Yeah, please do.
There's a lot of criticism about the plan, but it's the least bad plan.
There you go. There you
go.
There you go.
The most important thing is that it takes the money out of judicial selection, and where you have millions of dollars being spent in Illinois or Texas or Alabama or these other states with popularly elected judges, millions of dollars, and surely they're beholden in some indirect way, if not more, to the people who give them the millions of dollars.
Yeah.
That's the biggest benefit.
Well, and one PS to Judge Limbaugh, I think, is that the other real benefit is that it's to ensure that nobody who is not qualified is placed on the bench. Whereas in the Pendergast years and others, there were some people who were clearly not qualified because they were close to the political machine, were appointed, or where they were elected rather. So that's another insurance policy in a sense, because of all the vetting that has gone on before the names are sent to the governor's office.
Yes, thank you for those additions. And you know, there's no way that the governor could appoint their brother-in-law or their best friend. They're stuck with these names who this commission has vetted and found to be well qualified. Yes, and it is, Judge Limbaugh said, it's the perception, if you're involved in a case and your opponent has given, hundreds of thousands of dollars to the judge and their campaign, and you've not given any money, how do you feel? You feel like maybe you're at a disadvantage, that the playing field's not level. And so you want to walk into a courtroom with a judge who has no interest in the case, no knowledge, no favorite home team, if you will, and is willing, or will be making a decision based on the law and the facts, and not on any personal relationship or benefit from a financial interest in their next campaign. Yes.
So the governor appoints those that, so it's likely that whatever political party the governor is from is going to appoint judges from his party or her.
Well,
so it's political in that sense?
Well, it could be. Most of the candidates, and I can't say all, but most of the candidates or judges that are moving up the system may not have any political involvement. It may not be clear what their political allegiance in the past has been. And that's not a question that's appropriate to ask. Not that a governor couldn't have done some research and found out, okay, this person, has been on these campaign contribution lists, but some people have never contributed to a candidate. So I wouldn't be on any list, but I might have had some relationships in the past that might have given a governor a cue, but not all judicial candidates are in that boat. So and the names that the governor may receive may actually be associated with a party the opposite of the governor. So, but he stuck them with those three names. Okay, anything else about the nonpartisan court plan? Okay, moving on then, another huge change to the judiciary was a big reorganization plan that was approved by the voters in 1976. It was on the August ballot, and that was my first election, and I am sure I knew exactly what I was voting on. Article 5 of the Constitution was rewritten, and a big reform act in how our courts were structured. The old magistrate and probate judges, their functions, and those judges themselves were moved into the circuit courts. Appeals were consolidated into a single court of appeals with 3 districts, and that's when the names changed from Kansas City, Springfield, and St. Louis to Eastern, Western, and Southern districts. The Supreme Court began hearing cases en banc. That means all 7 of us, instead of hearing cases in divisions. The Constitution also didn't restrict where the Court of Appeals could hear their cases. So unlike the Supreme Court of Missouri, who our court is required to hold our sessions in the city of Jefferson, the courts of appeals could move around within their districts and hold their dockets in anywhere within their districts. And so when I was on the Court of Appeals in St. Louis, we would hold dockets in law schools, in undergraduate colleges. We held a docket at my high school in Hannibal, wonder why. We held dockets in senior citizen centers. We took a docket out to Merrimack Bluffs in St. Louis County and had a docket in front of a group of the greatest generation of citizens there. And that really brings the court closer to the people, and they can personally view it if they are able to travel or have the interest in going to watch the courts in these various locations. The consolidation of the courts also moved the automatic right to appeal in certain cases from the Supreme Court to the Court of Appeals. So it lessened the load, the jurisdiction of the Supreme Court. Municipal courts became a division of the circuit courts. So there goes our superintendent control over lower courts. That would include now municipal courts. And it amended the provisions regarding judges then had to retire at age 70 as opposed to the 65 provision that was established so many years before that. Consolidation also brought various elements of the judiciary into a modern coordinated system. For example, no matter a judge's home court, all judges are considered state judges, and any judge could be transferred from one jurisdiction to another jurisdiction to hear cases as the caseload required. Did you, Judges Covington and Limbaugh, ever transfer judges? all the time, all the time. The new program set up a senior judge program so that judges who had retired from the court could now have authority to be appointed to hear cases as a senior judge for very, very small pay. But instead of losing the expertise and experience of a judge who served for many years, we allowed them to continue to work. In July of last year, 2 judges who originally had been magistrate judges before they became associate circuit court judges under the new Judicial Reform Act, which actually went into effect in January of '79, were Judges Roy Richter of Montgomery County and Robert Dowd of St. Louis. And both those judges ended up on the Court of Appeals, and their 70th birthdays were in the 2020. They both have now retired from the bench. Our courthouses throughout the state are beautiful and historic and very interesting, and they continue to serve the areas in which they are located. Our Constitution requires that every county have a judge. So as you know, there's a courthouse in every county. They're usually obviously located historically on the town squares. They're at the crossroads of the activity in the community, and they're the hub of action historically in all our counties. You start looking at the pictures I'm going to show you here. Let's see, this is not in the right order, but the Lafayette County Courthouse in Lexington was built in 1847, and it's the state's oldest continuing operating courthouse. A cannonball from the 1861 Battle of Lexington during the Civil War remains lodged in one of the courthouse columns. Here is Iron County. This courthouse is located in Ironton, built about 1858. The building was used as both a barracks and a hospital during the 1864 Battle of Pilot Knob during the Civil War. Lewis County Courthouse is located in Monticello. Who's ever been to Monticello? Good for you. Yeah, I've tried cases in Monticello. There was no air conditioning even in the 1990s. So it was not a fun place in the summertime. Monticello is the state's smallest county seat. This courthouse was built in 1875, and it was one of the more ornate buildings of its style, and is one of Missouri's oldest remaining courthouses. Nottoway County Courthouse, located in Maryville. It was built in 1881 and is considered one of Missouri's finest examples of huge Victorian style. And finally, Jasper County Courthouse in Carthage. The county there uses 2 courthouses, the other courthouse in Joplin. But this building was built in 1895, Romanesque structure made of Carthage marble, the locally quarried limestone mix for which the city is famous. The entire courthouse square is a National Historic District. Our courts have continued to progress. This is more on the nonpartisan court plan, but we start now seeing some diversity in our courts. Historically, our courts have been composed of white men, but that started to change when Judge Theodore McMillian was appointed the first African-American circuit and appellate judge in our state. That was in March of 1956 that he was appointed a circuit judge in St. Louis City. He was the great-grandson of a slave, and he graduated first in his class from St. Louis University School of Law in 1949, but after graduation couldn't find employment. He formed his own law firm and later was an assistant prosecuting attorney in the city, but he got on the bench in 1956. He had been nominated 4 times under the nonpartisan court plan, but it was, I guess, his 4th time before he was actually appointed. Then later in 1972, he was elevated to the Court of Appeals in the Eastern District. And then in 1978, got the high honor of being on the United States Court of Appeals for the 8th Circuit. Then we have the famous Judge Ann Covington, yay, who we're blessed with right here in this room today, who became the first woman on the Supreme Court of Missouri. Mizzou graduate, had been in private practice, had worked in the Attorney General's office. She was appointed actually first to the Court of Appeals and was the first female to serve on any of the courts of appeals, appointed in September of '87. And she was appointed to the Western District Court of Appeals in the Kansas City area. And then later in December of 1988 was appointed to the Supreme Court of Missouri. And she served as our first female Chief Justice from 93 to 95. And many of us women think of her as our godmother and feel none of us would be on the court if it wasn't for her. I mean, we could have got a dud for
We
the
called her our den mother.
den mother, okay. we think we could have had a real dud for the first woman who could have ruined it for us, but because we had a wonderful woman who could walk into an old male bastion and could, get along and collegially work with the men who had never had a woman as a colleague before, but yet still remain her feminine character, was a miracle. And so we still feel very blessed that we have started it all with Judge Covington. Oh, should we all applaud? Yes, that's very good. Let's all applaud. And I think she's prettier today than she was then. What do you think? Anyway, so the first African-American woman to serve on our circuit bench was Judge Evelyn Baker, who was appointed in May of 1983, and she was appointed to the St. Louis Circuit Court. I might backtrack for a second. The first woman on the circuit bench in our state is believed to be Ellen Roper here in Boone County, and she was appointed in January of '79. Judge Baker was appointed in '83 from the. Oh, okay. Then she was elected after that, Bill?
She was elected before that as the
Probate.
judge, and the probate judges became circuit judges under the
Sure.
Constitution.
Okay, thank you. Yes, I should have said it. Thank you. Yes, you're right. So she became the first female circuit judge in January of '79 as a result of the reorganization plan of the courts. Yes, thank you. Then we move on to the first African-American woman to serve on our courts of appeals was Lisa White Hardwick. She was appointed to serve on the Western District Court of Appeals, and Judge Hardwick is still a member of that court today. The first African-American to serve on the Supreme Court of Missouri was in October of 1995, and that was Judge Ronnie White. He had previously been on the Court of Appeals in St. Louis, and he today now is a member of the U.S. District Court in St. Louis, the court where Judge Limbaugh is currently a member. On our court, since Judge White's appointment, he's obviously come and gone. Judge Draper, our past CJ, is the second African-American judge on our court. And then just most recently here in May, the third African-American to ever be appointed to our court, Judge Robin Ransom, was appointed by the governor under the nonpartisan court plan. And so today, out of 7 of us, we have 2 African-American judges, and we have 3 female. So not enough females, but we're going to keep working on that. Then, as time goes on, the public started expecting courts to do more, not just to decide cases, but to help, be problem-solving courts. So in 1993, the first treatment court, first drug court, opened in Jackson County. In '98, the legislature passed legislation enabling statewide treatment courts. In 2010, the legislature expanded treatment courts to allow for DWI courts. In 2013, to allow for veteran courts. And now, Missouri treatment courts include drug courts, DWI courts, family and juvenile treatment courts, and veteran and treatment courts. And in every circuit, there is some treatment court in existence. They've been widely popular. They've been successful. They have helped people with problems not be thrown away in jail or prison forever, to never be treated for their illness, but to help them find a way to resolve their illness, to become productive citizens, to become employed, and to become working member of our society, and to be functioning in their own families. Going to skip over something here just a second. By 2020, we now have 46 judicial circuits in our state, 3 appellate districts, and you can see how all the circuits are all the appellate districts are in different colors, and the circuits are by numbers. The newest circuit court, the 46th Circuit, was created when Taney County was separated from Christian County to form its own circuit in 2020. This was pursuant to legislation that was required the courts to realign and to move 2 counties into different circuits. So 2 of these counties, Benton County was moving from the 30th Circuit to the 27th Circuit. That will be effective next January. Carter County will move from the 32nd Circuit to the 36th Circuit, and that's scheduled to occur January 1 of 23. So you can see where you live, and you can see which county is in which Court of Appeals district and which circuit number you are. We don't know what the state will look like going forward the next 200 years, but that's the way we are set up today. Our courts continue to be diverse. Right now, 71% of our judges are men and 29% are women. Nationally, 30% are women. In Missouri, 36% of our practicing attorneys are women. In Missouri, 36% of practicing attorneys and 29% of judges are women. In 2018, Missouri estimated our population to be 51% female. So we are just a little behind our total population. As far as racial diversity, 14% of our benches are minorities. Nationally, it's 20%. In Missouri, 11% of our practicing attorneys and 9% of our judges are minorities. In 2018, Missouri estimated its minority population to be 19%. During COVID and the pandemic, courts had to quickly adapt to conduct proceedings. Our courts were never closed. Some trials were delayed for a period of time, but most of our courts were very creative in how they continued to conduct jury trials to protect the public. I started keeping a list of all the interesting places that voir dire, which is the selection method for members of the jury, took place in such places as auditoriums, performing arts centers, schools, even in the Bass Pro Lodge Museum down in Springfield, sitting underneath a bear, there was judges conducting voir dire. But because the judges had to be creative and get up to speed on such platforms as Zoom and WebEx, proceedings were allowed to continue. And there's been good and bad with it. Some judges tell me from the trial bench that now they have more attendance at proceedings, that people don't have to take off work. They can go into a break room and make their court appearance. They can go out into the parking lot and sit in their car and make their court appearance. So there's a lot more participation than before. There's some negatives that exist by not having the person there in the courtroom in front of the judge. There's always technological breakdowns that take place, or the common phrase, judge, you're on mute, or sir, your screen is frozen. But our judges had to be nimble and had to be adapted to our new technology. And going forward, we will see some of these proceedings, not all, of course, that will continue virtually. It will save attorneys from driving, like the general counsel's office, Mr. Owen's office, all over the state for a 10-minute court appearance. It can be done virtually now. Not all proceedings, of course, jury trials and other proceedings, would be benefited by being in person. But this technology is going to help us to be more efficient and to conduct justice better. The picture I'm going to show you is how we did business at the Supreme Court. So because all of our sessions have to be conducted in the city of Jefferson, in those early scary days of COVID, Judge Draper, our Chief Justice, came in and held court. The rest of us were sitting in different places. Maybe we're up in our offices so that we wouldn't be too close to anybody, or maybe we were at home in our home offices. In those early days, the joke was I was sitting at my desk at home and I was wearing a robe, but it wasn't a black robe, it was my white bathrobe. So in any event, we were all connected and we could hear and see the attorneys arguing. We could ask questions, albeit, you were doing it virtually. Proceedings still took place. This is a picture of Andrea Vanderlit, who is one of our trial court judges. She's up in Sheraton County, and here she is conducting a court proceeding on WebEx during the pandemic. This was in June of this past year. So I don't know, what do you think? Who would have imagined this technology being used today? And what do you think we'll have in the future? So just in conclusion, although our courts today look different, the buildings are more modern, the technology we use is never even heard of or thought about 200 years ago. The judges look different. But despite all of these differences, the bottom line of remaining dedicated to providing justice and fairness and equality to all still exists, and we are confident will exist for the next 200 years too. Thank you.